heard appeal on the matter of Dentons UK Middle East LLP and Solicitors Regulation Authority Limited.
My Lord and friends, kindly given me a moment just to mention that in response to requests yesterday, we've provided two further pieces of material. One is the Holden case about the accounts rules, which is referred to, you recall, at paragraph 158 in Lee Day. And I think it may have been my Lord Justice Jeremy Baker who asked to see that. So you've got that. The relevant paragraphs for your note, when you look at it in particular, one, if you've got it there, Holden, one, have we got, I think we've got hard copies on the desk or on the way to the desk.
No.
Possibly, no. Oh, they are on the desk there. If they could kindly, thank you very much, be passed up to their lordship. I don't want to spend my learned friend's time taking you through them, but just to give you the references, you should have the case of Holden, if we could deal with that first.
Yes.
Please. The relevant paragraphs to look at in due course, in particular, are 1, 2, 7, 14 to 19, and 22 to 29.
Yes.
Read in conjunction with paragraph 158 of Lee Day. And the other item is the full copy of the SRA Disciplinary Rules of 2011, which my Lord Justice Zacaroli was asking about yesterday. You have only an extract at the moment at tab 51. The relevant provisions is, for our purposes as we see it, rules 1.1, 3.1 and 10.1. So when I say rule 1.1, it's in particular the definitions of disciplinary decision and SRA, disciplinary decision and SRA finding. Disciplinary decision and SRA finding. Well, Lords, that's all I wanted to say at this stage. Thank you.
So we find these poems.
Yes, I suggest that the rules be put in tab 51 with the incomplete extract that you've got there at the moment. Is there I think as regards Holden, the only natural home might be at the back of volume 5.
Yes.
After tab 68.
Yes, Mr. Rosing. Oh, still on housekeeping. Thank you for day one transcripts which arrived electronically overnight. Yes.
Lords, I'm going to try to approach our response by taking the grounds in order, and I'm going to go on in a moment to give some key responses without trying to repeat everything that we put in our skeleton argument. in relation to approach 1, as it's characterised by my learned friends, in relation to ground 1 being, to paraphrase, the firm's contention that the judge was wrong to conclude that the tribunal was not entitled to dismiss Principle 7 and Outcome 7.5 allegations on the grounds that the proven breach of the MLRs was not serious. Or perhaps I can characterise my learned friend's submissions as seriousness plus the familiar mantra of serious, reprehensible and culpable, which of course the court will appreciate is a somewhat different creature to seriousness simpliciter.
Anyway, you said no requirement of seriousness simpliciter.
Indeed. So key point number 1 is that the judge was right, we say, to find that the natural and ordinary meaning of the provisions, the grammatical meaning, was that there was no such requirement, no requirement of seriousness plus, or indeed seriousness at all. And the judge said that in clear terms. I don't think we need to go to it. Paragraph 69 in her judgment, Core Bundle, tab 5, page 98.
I think she said it was common ground. No, nobody suggested otherwise.
That is a helpful reminder, and I don't detect that the learned friend has departed from that position in the course of his submissions before this court. So I take it that it is common ground, and indeed that's why the burden of my learned friend's submissions is that there are an accumulation of considerations that displace the grammatical meaning. And that is the essential thrust of the arguments that you heard from the learned friend over the course of yesterday. I don't think it's necessary to go back in detail to look at the nature of the principles and the code which led to that conclusion, because my learned friend invited the court to look at those provisions yesterday. But I will, if I may, sketch out a few points with reference to the relevant provisions. And I'm going to invite the court to look at 2, in fact, that may be of significance within the wider context of this appeal.
Sorry, to establish what? I mean, you said there were a number of principles. You began with one, which,
Yes.
so far as I can see, is common ground.
Yes. It gives rise to the grounding of the weight that my learned friend needs to displace. That is to say, the strength of the grammatical meaning of the rules. So it's not just a case of it is accepted that the rules have this effect. They have a strong weight to them. That is to say that they are mandatory provisions and properly construed. They contain no such requirements. Search as you may, you will not find it. May I move on to the specific features that I don't think we looked at and may be of some significance? The first is, this is Your Lordship's tab 49, where the principles can be found. and it's paragraph 2.3 in the principles at page 1346. And your lordship will see that these are the notes to the principles. 2.3b is the one that I'm inviting the court to look at. These principles B will be breached by you if you permit another person to do anything on your behalf which, if done by you, would breach the principles. And your lordships may think that within the wider context of the factual matrix that has some significance in the sense that although there wasn't detailed consideration by the SDT as to the basis upon which the firm was responsible for the acts of Mr. Chatto, this is certainly one possible basis. The other possible basis is, of course, Regulation 17 of the Money Laundering Regulations, which dictates that if you allow somebody else to carry out due diligence on your behalf, you remain liable with respect to the due diligence. The other short point that I would invite your lordship to have regard to is a few pages on page 1352, under paragraph 5, application of the SRA principles outside practice. So this is an express provision which regulates that question. And it says, in relation to activities which fall outside practice, whether undertaken as a lawyer or in some business or private capacity, principles 1, 2, and 6 apply to you if you are a solicitor, REL or RFL, European lawyer or foreign lawyer. European lawyers now being a category that has largely given way to foreign lawyers. And if one glances back at 1345, one can see how that breaks down. So the ones that are applicable outside of practice are upholding the rule of law, number 1, number 2, acting with integrity, and number 6, behave in a way that maintains the trust the public places in you. It's significant, we say, that 7, complying with your legal and regulatory obligations, is not within that list. That is as it were, a proportionality safeguard provided by the structure of the rules.
Mr. Coleman, I think, told us yesterday that before the judge, you were contending that a solicitor who, say, was convicted of a speeding offence could be proceeded against for breach of Principle 7, but you concede that that's wrong because
I'm not sure that I made that submission. I think it may have been entertained in the skeleton argument before the judge, which I did not draft.
Right. Well, anyway, your side.
As I recollect it, one obviously should be wary of phantom recollections. It was a distinct feature of the way we presented the case that outcome 7.5 was confined to within practice conduct. Right, it may not matter. trying to anchor this to the submissions in our skeleton argument, we make the point that Chapter 7 is going to confine to within practice conduct, that's our paragraph 26, and that outcome 7.5 is a mandatory provision requiring compliance with legislation and specifically the anti-money laundering and data protection legislation. That is our paragraph 26. So, key point number 2, the regulatory context is consistent with that grammatical interpretation. This is largely our skeleton argument, paragraph 33. And I've already foreshadowed what I wish to say in relation to this in the remarks that I addressed the court with yesterday concerning the statutory underpinning of the rules which governed the SDT proceedings. And to summarise, we say there is no inference to be derived from the wording of the rule-making powers under which the rules were made, that the rules made under them relate to professional misconduct as a defined term at all, and in particular as a defined term with connotations of seriousness or seriousness plus. Now, it's right to say I considered this matter overnight, and professional misconduct, the term professional misconduct, is used elsewhere in the Acts, but as a generic, undefined term. So there are a raft of provisions introduced by the Legal Services Act, Section 44B, Section 44C, Section 44D. We've not provided them, but we certainly can. But they relate, to borrow a Beckwith phrase, to the use of that phrase as a proxy term to denote what is done in relation to conduct concerns by way of investigation or proceedings. So it's, for example, power to charge for costs of investigation, matters of that kind. But there is a provision in the Administration of Justice Act, Section 44D, which rather hedges its bets and says, uses the phrase, here's a charge of professional misconduct or breach of professional standards against a barrister, it may order that he shall be excluded from criminal legal aid work. So, as a matter of candour, we draw the court's attention to the fact that the phrase professional misconduct is used, but in a way that is undefined in either statute. And has
in either the Solicitors Act 1974 or
the Administration of Justice Act. And is used in that generic kind of way that I sought to outline. The second subheading to point number 2 is again the point that I outlined yesterday, that the Society and the SRA through it has legal obligations widely defined as an approved regulator under the Legal Services Act and as a supervisory authority under the MLRs to promote appropriate standards, not limited to misconduct or serious plus misconduct, in fact widely defined, dealing with areas of activity that are properly regulated, relating to regulated people, and to take necessary measures to secure compliance with the MLRs. That's Regulation 24 of the MLRs. So the long and short of it is that the SRA needed to promulgate a standard that did so. There was a legal imperative for it to do so, which feeds straight into Principle 7 and Outcome 7.5. That's why they are there. Point number 3, which is developed in our skeleton argument at paragraphs 35 and 36, is a rather more commonsensical proposition, which is this, that compliance with all laws, as opposed to just compliance in a way which avoids serious criminality, is an appropriate regulatory objective and standard with respect to the regulation of lawyers. And in particular, in relation to the AML, anti-money laundering context, where lawyers are under specific legal duties for which the SRA is obliged to promulgate appropriate standards to give effect to those duties, in recognition of the pivotal role of lawyers in an AML context as the gatekeepers to certain high-risk transactions. And that's related similarly to the point which we advanced before the judge, and the point that she accepted, which is that although Principle 7 and Outcome 7.5 have the character of strict liability provisions, they nonetheless are, they stand on the shoulders of an anterior finding with respect to MLR breaches of a breach of the MLRs. And so the breach of the MLRs is baked in to the standard.
In this case?
In this case, not in all cases, I accept that. But in this case, with respect to money laundering breaches, that is the position. Point number 4 is that the firm's argument that the grammatical meaning of the standards should be displaced by considerations relating to the regulatory scheme and its common law underpinning is answered or rebutted by a number of distinct considerations. So I've now got sub-points to my point number 4. The first point, which my learned friend addressed to some degree yesterday, is that the 2007 scheme, and this may be more applicable to the 2011 scheme, but certainly it starts off with the 2007 scheme in the SRA regulation, was a radical departure from what had gone before. And it is, of course, significant that it corresponds with the regulatory structure introduced by the Legal Services Act 2007, imposing those obligations specifically upon the SRA. The learned friend invited the court to look at Cordery, But I invite you to go back to
Are you saying that the threshold changed?
the point here is not so much that the threshold changed, but that there is limited weight that can be placed on common law principles that predate 2007, because the standards were radically reformulated. So the gravitational pull of ancient common law, or old common law, that the learned friends rely upon, the inherent jurisdiction of the court, cases like Myers, has a limited gravitational pull with respect to a wholly new set of standards introduced properly under parliamentary authority by the SRA in pursuit of its regulatory objectives.
Well, that seems to me a very important submission. Are you saying in effect that even if Mr. Coleman satisfies us that facts such as these would not have met, if he satisfies us that there was a threshold of seriousness applicable to disciplinary charges against solicitors before 2007, and that these facts don't meet it, you're saying, well, Parliament has abolished such seriousness threshold as there may once have been.
Yes.
Has that ever been held by any court? Because that's a very important proposition, that is the effect of the Legal Services Act.
I don't think so, but I think that's largely because until Lee Day, the issue recurring in Beckwith and in this case, it wasn't suggested to any court in a way that mattered for the purposes of a decision, that there was a seriousness or seriousness plus standard that needed to be imported with respect to standards that on their face did not contain such an injunction. And of course, in other schemes that specifically use the phrase professional misconduct, and where there is a body of common law that is to the effect that professional misconduct denotes something that has a very high threshold, the issue wouldn't arise, because that is a feature of that particular framework. That applies to the GMC proceedings, where under the old scheme, the phrase that stipulated the standard that had to be breached was serious professional misconduct. And after Meadow, the decision of the Court of Appeal in Meadow, it was held that despite the fact that the phraseology had changed, it couldn't possibly mean a lower standard. But that's a different position to the position that prevailed in relation to legal services.
GMC test used to be serious professional misconduct. It's now, isn't it, simply an aspect of impairment of fitness to practice?
Yes, impaired fitness to practice, comprising a number of subheads, including misconduct, deficient professional performance,
yes,
etc. it's dealt with in the case of Calhoun.
Yeah,
We've
I
cited.
I don't think we need to go down that route, but
So I understood that submission until we talked about the GMC to be that if there was a regime, or if there's a regime which uses the phrase professional misconduct, then that might be said to incorporate the common law which says professional misconduct has a threshold of seriousness. Am I wrong about that?
Well, it's going to be a fact or scheme-specific assessment, but certainly it's a starting point. If the scheme actually refers to professional misconduct, you then have to ask yourself, well, what does it mean within the overall context of the scheme? But if it doesn't even say that, as it doesn't here, then you don't even have that starting position taking you towards the conclusion that seriousness is required.
Slightly concerned about getting bogged down in semantics here, because these are conduct rules in relation to professionals,
Yes,
where sanctions can be brought for breach of them.
yes.
I mean, it may be said that's obviously professional misconduct. I mean, it's the starting point, I suppose, is the conduct rules.
Well, in a Beckwith kind of way, yes, that they are conduct, that they are rules relating to the conduct of professionals, and so it's appropriate to use a generic term that you're dealing with professional misconduct. But I think maybe your lordship is inviting me to consider the question of inappropriate stigmatisation for trivial breaches. But one answer to that is that if the reality of the matter is that your professional misconduct scheme contains a variety of reasons for regulatory intervention, including ones that do not require proof of seriousness, proof of reprehensible or deplorable conduct, then you are not, in fact, dealing with inappropriate stigmatisation, because the stigmatisation is commensurate with the stigma attached to the standard that has been breached. So we would respectfully submit that the mere observation that, of course, you're dealing with professional misconduct doesn't take one to the view or to the conclusion that it must necessarily incorporate seriousness or some seriousness plus test. Because, in fact, that would defeat the purpose of standards that are articulated deliberately as not to incorporate seriousness or seriousness plus. And why should the regulatory scheme deprive itself of the ability to regulate such conduct by imposing a higher bar than is necessary, a bar that gets into the way of proper regulation?
Can you help us with the relevance of the SRA disciplinary procedure rules referred to yesterday and handed up today? You all know them better than I do, but the SRA by Rule 10(1), the SRA may make an application to the tribunal in respect of a regulated person at any time, if the SRA is satisfied there's sufficient evidence to provide a realistic prospect that the application will be upheld. The allegation to be made against the person under investigation, either in itself or in the light of other allegations, is sufficiently serious. The tribunal is likely to order that the person be subject to a number of penalties.
Yes.
One of a number of penalties. So that there's a seriousness test which the SRA is supposed to apply.
Yes.
But I think you say that once the case is before the tribunal has no power to say, why are you wasting our time? This is trivial, go away. It has to hear the case to its conclusion. And if you're right, if a breach of Principle 7 is proved, they must say fined without any threshold of seriousness. That's your case, isn't it?
In broad terms, yes. The Lord will have seen that we sketch out the various ways in which the tribunal can assess the merits of the case at an early stage. Rule 13.
Of these rules?
No, once the case is referred to the tribunal.
Yes.
Once the case is referred to the tribunal, points at which the tribunal can assess the merits and conceivably lead to an early disposal of the matter is Regulation 13 of the Solicitors Disciplinary Procedure Rules, which allows it to consider whether there's a prima facie case. And if you're articulating a standard that has built into it inherent seriousness, such as...
Can you just show us that regulation?
Yes, I'm slightly jumping ahead. That is no difficulty. I was going to come to that. Page 1410 is the Solicitors Disciplinary Proceeding Rules. And then within it, page 1419, your Lordship can see Regulation 13, certification of case to answer. And you will see subsection Rule 13.1, an application made in accordance with Rule 12 must initially be considered by a solicitor member, the initial solicitor member, for consideration of the question of whether there is a case to answer in respect of the allegations made in the application. And in short, the case can be dismissed if there isn't a case to answer. So it's a filtering stage at the time that the SRA refers a case to the tribunal. The tribunal itself gets the chance to weed out cases for which there is no case to answer.
But isn't this the equivalent of Galbraith in the Crown Court? I don't read this rule as saying that the solicitor member can say, well, this isn't serious enough to be worth 3 days of our time or whatever.
Well, if it is a provision such as contravention of a standard that articulates a requirement not to bring the profession into disrepute or matters of that kind, then yes, the solicitor member could say, well, what you've alleged is not serious enough to satisfy that standard.
What about a breach of Principle 7?
They can't say that because
So
there isn't.
what is the relevance of that then to this matter?
I think I was addressing the specific question that I was asked, and I forget precisely what it
Well,
was.
can I put
Yeah.
it to you another way? I think you've accepted this morning that so far as Principle 7 is concerned, something which has nothing to do with the solicitor's working life, such as contravening the speed limit,
Yes.
it's got nothing to do with it.
Yes.
But suppose that there are many legal obligations attaching to, for example, the ownership and running of a building.
Yes.
Suppose that this firm or any other owns the offices from which it practices. And let's suppose, I think I'm not making this up, that there are health and safety requirements to have a fire extinguisher on every floor of the building. And let us suppose that it may be a criminal offence if there aren't. So health and safety inspection takes place, in the course of which an inspector observes there are no fire extinguishers, and a prosecution is brought against, in this case, the LLP running the building, and a magistrate's court imposes a fine of X thousand pounds. Suppose that the SRA brought a case against the firm, the managing partner, and say you are in breach of legal or regulatory obligations concerned with the running of the building, not your private home, and we think this is a matter which justifies bringing the case before the Solicitors Disciplinary Tribunal. You can't dispute that this in fact occurred. We have the magistrate's court conviction to prove it. As I read Rule 13, the solicitor member can't say this is absurd, this is trivial, go away. The case has to proceed to a hearing, and are the tribunal bound to find the allegation of breach of Principle 7 proved?
The short answer is yes. And Your Lordship selects, not perhaps quite the reductio absurdo, but it is the important case that calls for consideration. That is to say, a trivial within practice breach.
Yes.
What happens in relation to a trivial within practice breach? Well, the first answer, I suppose, is the process is bookended by the proper consideration of seriousness. That is to say, the SRA has got to consider seriousness before it makes a referral.
In the example I've given, would the firm be able to apply to the High Court for judicial review of the SRA's decision to take the case to a tribunal, notwithstanding the firm would say that nobody could reasonably suppose that the tribunal is going to impose a penalty beyond the SRA's in-house powers?
I think the learned friends address this. There is, of course, a tightly constrained jurisdiction to review prosecutorial decisions in relation to criminal proceedings, and the same principle applies to regulatory proceedings. But it has limits, and whilst I wouldn't want to make a concession on behalf of the SRA, there may be limits which allow for the supervisory jurisdiction of the High Court.
But if that remedy isn't available, then there is no remedy, and on your case, the case must proceed to a
The case
full
must
hearing
proceed.
before the SDT.
Yes, the case must proceed, but there are perhaps two answers. One is, as I said, the process is bookended, so seriousness comes into play at the sanction stage, and the tribunal.
Well, of course it does, but and my question is whether one gets that far.
Yes. Well, the answer is yes, one does, with respect. There may be a middle way, which those who work in regulatory work or criminal work will be familiar with. The same principle applies to prosecutorial decisions. There is a tightly constrained jurisdiction that operates with respect to the review of prosecutorial decisions, or indeed the position that the Crown Court is in with respect to a case which it thinks should never have been prosecuted.
Well, the Crown Court, on the whole, a judge has no power to say.
I think on the high authority of Humphreys, if I remember rightly, House of Lords authority. But the Crown Court can say, and often does say, I know that this division has experience of criminal cases. It can say, go away and think again.
Yes, of course. But if the prosecutor stands his ground,
Yes.
and say, I've considered, I've spoken to the Chief Crown Prosecutor, we are going ahead with
Yes.
this, and there's nothing you can do about
Yes.
it. Would no doubt be put politely, but that is the law.
And rightly so,
Yes.
if I may respectfully say. I think perhaps I'll try and dig it up over the lunch and adjournment on the high authority of Humphreys, because there is a proper separation of functions. And the same applies here, we would respectfully support. And indeed, if I have time, when I address the court on approach 2, I'm going to try to sketch out why the separation of functions is embedded in the statutory framework.
I just looked a little lost. What was the possible middle way, besides the fact that it's a
Yes.
controlled type of scheme whereby certain standards by the SRA would be reviewed before they decide to effectively prosecute?
Yes. The tribunal saying to the prosecutor, or in an SRA context, the presenting counsel, do we really need to spend a week litigating this? Have you thought about it properly? Could you take instructions at a high level? And of course, if the SDT made such an invitation, it would be an invitation that would be taken up. The SRA, just as the Crown Prosecution Service, may stick to its guns and say, we're going ahead.
Can I ask a last point in this sequence of questions? What are the SDT's powers and duties on costs? In the example I've given, the SDT is forced to go ahead with the fire extinguisher case, and after, say, 2 days, if you're right, says we have to find the case proved. Mr. Ozen persuaded us that we have no power to dismiss the case on the basis of triviality. So there is a breach of Principle 7. What are they allowed to do about costs?
That there is developed jurisprudence in relation to the constrained jurisdiction to make a little costs against the regulator, the Baxendale-Walker line of cases. It's been modified in recent years by yes, and there's a case of high authority. Its name is Farmer. Yes. So it used to be based on the chilling effect on a regulator in bringing regulatory proceedings, and the old test used to be formulated with the use of such phrases as "it has to be a muddle from start to finish, a wholly misconceived."
But that's when there's an acquittal, to use a shorthand phrase. Even if a charge is dismissed,
Yes.
the power to award costs against the regulator is very limited, isn't it? But if the tribunal is forced to convict in a case where it considers that its time has been wasted, does it have any power to order costs against the regulator? I would be surprised if it did.
I'm not sure that I have the answer at the tip of my fingers. So
Well, let
will-
us know this afternoon.
Yes.
It could say, we are not going to award any costs against the firm.
Yes.
Okay. Right. Thank you, Mr. Rosen. Sorry. Subject to my
sorry
comment.
to prolong it a little bit
Yes.
further, but you mentioned before this exchange the separation of powers.
Yes.
What between whom?
Between the SRA as prosecutor
Yeah.
and the tribunal as adjudicator of the standards that apply to the allegation.
So that separation is muddled or muddied somewhat in our environment by the fact that the SRA itself is prosecutor and decision maker at stage one. Because it's only if it gets beyond above a level of seriousness that it sends it to the tribunal. And importantly, at stage one, under the current rules, it can't make a decision unless the breach is serious.
Yes.
Under the old rules or the applicable rules, you showed us what Mr. Coleman handed up 3.1. There, that a condition of making a disciplinary decision is that one of the conditions is that the breach is neither trivial nor justifiably inadvertent. So a similar.
Yes, I think the current test is precisely equivalent to the Code for Crown Prosecutors full code test: realistic prospect, public interest.
But this is not in the context of a prosecution decision. It's in the context of a decision to impose a sanction itself.
I see. Yes, but that is a familiar situation. I would respectfully submit that there are two streams. There's a regulatory stream and there is a prosecutorial stream. The same applies to FCA proceedings. Sometimes you have an overlap. And considerations that apply to the regulator exercising its own enforcement powers are, I would respectfully submit, wholly different to those that apply to tribunal referral, the tribunal referral, tribunal consideration track.
And you would say that the fact that these rules impose a threshold before the SRA can impose sanction, seriousness,
Yeah.
is irrelevant when we're construing the tribunal's powers.
Yes, I do.
And why is that? Why is it irrelevant?
Because precisely for the reason that your lordship has articulated, that in this respect, in the regulatory stream, the regulator is prosecutor, judge and jury, whereas in relation to the tribunal stream, it is just the prosecutor. And it's got to carefully consider which track to employ. The rules that we we're looking at do just that. Again, perhaps jumping ahead, I think this was prompted by the Lord Justice Zacaroli's questions yesterday. Under the old scheme, the handout that the court has received today, there are earlier rules allowing the SRA decision makers to take enforcement action. Specifically, I think disqualification from a person acting as a hope or hofer, head of legal practice or head of finance and administration, and also a financial penalty.
Sorry, where are you reading from, Mr. Rosen?
The Lord, it's the earlier provisions, I think, in recollection 8, there are provisions that allow the SRA decision maker to consider the imposition of those enforcement. So, for example, Rule 8, decision to impose a penalty, which comes before Rule 10. Rule 9, decision to disqualify and to review a disqualification. And then Rule 10, 10.1, the SRA may make an application to the tribunal in respect of a regulated person at any time. And then it articulates the referral test as it was then formulated.
Because I was in fact taken to Rule 3.1.
And under the current scheme, which I think prompted my Lord's questions yesterday, there are similar, a wider range of enforcement actions that the regulator can take itself. Rule 3.1 is the decision-making gateway, as it were, and G allows for an application to be made to the tribunal, which then takes you to the screening referral test, the threshold test at 6.1, now reformulated in a way that corresponds precisely to the full code test for Crown prosecutors. Obviously, the public interest test is, the court may think, necessarily encompasses considerations of seriousness. Because if a case is not at all serious, it may not be in the public interest for it to be brought. It's a wider head.
But that's in relation to allegations that are proved in the SRA's view. Is that right?
The SRA has got to first of all decide, is this something that's suitable for regulatory enforcement? Yes, actually your Lordship is right, I understand the point. In order for regulatory enforcement to take place, the decision maker has got to find the allegation proved. In order to make an application to the referral, they don't have to find it proved, they just have to find that the 6.1 test is met.
But in relation to finding the allegation proved, we go back to Rule 2 of the current.
Yes.
And there's no allegation. An allegation itself is defined as a breach which is serious.
Yes. But as I've said, my submission is it's a familiar situation, and it is explained by the different characteristics of regulatory enforcement by the regulator itself. I was going to, if I may, go back to the structure that I was adopting in my earlier submissions, and the point here was point number 4. Firm's argument that the grammatical meaning of the standards should be displaced by the regulatory scheme is rebutted by a number of considerations. Of course, the first one is, in effect, my point number 2, which is a proper understanding of the regulatory statutory context, indicates that the grammatical meaning is entirely consistent with the regulatory context. And then the point that I was seeking to develop was that the 2007 scheme represented a radical departure from what had gone before. Conscious of the time, it may be, subject to the court's view, that I can sketch out what I say the commentary establishes by giving the court references without going to the passages themselves. There is one passage that I think is helpful to go to, but I'll see if I can sketch out what I say the other bits of commentary establish. Caudery on legal services, authorities, tab 67, page 1656 to 1657. This is where the phrase radical departure comes from. Although it's fair to say I think the authors date the radical departure from the 2011 scheme as opposed to the 2007. And with respect to both schemes, the authors talk about the focus on outcome-focused regulation. And I think my learned friend took...
I'm sorry, Mr. Joseph. If you're going to refer us to things, I think you have to show.
So,
You have to show us.
I understand. Could I invite the court to look at page 1656? So this is Caudery, and this is under the title of The History of the SRA Codes of Conduct. And if you cast your eyes to the bottom of the page, the Guide to Professional Conduct of Solicitors was replaced in 2007 by the Solicitors Code of Conduct 2007. This was the first time an all-encompassing code was developed. This included overarching principles. The new code was published under the branding of the newly established Solicitors Regulation Authority. However, the origins of this code predated both the Legal Services Act and the separation of the regulatory and representative functions of the Law Society. And over the page, in October 2011, the 2007 code was replaced by the SRA Handbook, which contained within it revised principles and a new code based upon the concept of outcomes-focused regulation. This was deliberately intended to mark a radical departure from what had gone before. And it goes on to describe the structure of the new scheme. And I think the low friend's point was, yes, it was a change, but the change related to the outcome-focused regulation. Well, we would respectfully submit that is a point in our favour, in the sense that it indicates that an approach was taken which was consonant with the SRA's obligations under the Legal Services Act to promote the regulatory objectives by outcome-focused regulation, focusing not on the determination of moral opprobrium, but the determination of whether appropriate standards are being reached and maintained. The next reference is, I should say this is set out in our paragraphs 37 to 39.
Yeah, but by all means, if you've set something out in with a complete quotation in your skeleton argument, you can take us to that.
I don't think we do. I don't think we do.
Right.
But we set out the references in support of the proposition that there was a radical change. Could I invite you to go to tab 48, page 1324. I think we have the original version in the supplemental authorities bundle produced by Miller Friends, but I don't think it's materially different. Paragraphs are top paragraph. The 2007 edition marked a significant change to the historical approach to setting standards for solicitors. This 2009 edition comes barely 2 years later, and that's the point, essentially. The next reference is Gould at tab 66, page 1648. Paragraph 4.5, codes which followed the Legal Services Act 2007 might be said to have reflected a mix of approaches and concepts. Some provisions set out structures as were adopted by those regulated, others referred to desired outcomes or goals, etc. So it goes on to describe the nature of those new schemes. The essential point is it's a new scheme. And then perhaps the high point is the introduction to the, I say annual, I think it's not quite annual, the Solicitor's Handbook, at that point edited by Hopper and Treverton Jones QC. Authorities, tab 65, page 1643. This is part of the Solicitors Handbook 2008 by Andrew Hopper, Queen's Counsel, Gregory Treverton Jones, Queen's Counsel. Paragraph 3.2 at the top. The new code abandons the historical approach of relatively narrow practice rules and wider but non-exclusive official and published guidance. Instead, it creates a comprehensive regulatory framework for all aspects of a solicitor's conduct. I'll skip to the next paragraph. It seems that from the 1st of July 2007, there is in effect no such thing as non-statutory misconduct.
What does that mean?
That the common law is effectively superseded by the comprehensive code as to what constitutes a failure in professional standards by solicitors or those regulated by the code. That's how I read it, obviously.
Would it also possibly mean that it's you either go under the code or you can't go against a solicitor or what used to be common law professional misconduct?
Yes, subject to the inherent jurisdiction of the court. but yes, I respectfully agree. And the point is,
so non-statutory means not set out in the rules.
indeed,
Yes, well, that's
because, and this is developed
yes.
in the next paragraph. I think the next paragraph actually amplifies the meaning. Paragraph 3.3 on the page. The code is a blend of the familiar, the slightly different, and the occasionally very different, and then it sketches out the structure. Then importantly, in the next paragraph, it should not be overlooked that the code has implications beyond the personal conduct of an individual solicitor. The code is delegated legislation, and such has the force, and as such has the force of statute. This is a proposition, pausing there, that we adopt, having cited the same authority, Swain. This means that the code takes precedence over existing common law. And we respectfully agree. And that makes good that we say the point that we make in our skeleton argument at paragraph 38, that case law decided, this is in relation to the 2011 principles, but the same applies really going back to 2007. The 2011 principles obviously having particular significance in relation to P7 and O7.5. We say case law decided prior to 2011 has little or no bearing upon the interpretation of its provisions. My second sub-point, I'll call it B, to my point 4, is that the court's inherent jurisdiction to regulate the conduct of solicitors gives way to the SRA's disciplinary functions exercised under the authority of Parliament. And the authority for that proposition, this is our paragraph 38 in the skeleton argument, is the Cole-Floriat case, where we do set out, I don't think, unless your lordships wish to look at it, we need to go to the authority itself. It's in the authorities bundle at tab 26, page 619, and the relevant passage, paragraph 45, is at page 634 in the bundle. And the long and short of it is that the court will not exercise its inherent jurisdiction if the matter is more appropriately dealt with by the SRA, exercising its disciplinary functions given to it by Parliament. So we would submit that a wider point emerges from that. Preserved inherent jurisdiction is not a guide to the nature of the statutory jurisdiction under the schemes promulgated by the SRA. So, for example, my learned friend invited the court to look at Myers and Ellman, which is about the exercise of the court's statutory jurisdiction. Just to prove that I looked at the transcript, you'll find my learned friend's submission's key submission at pages 131 to 132 in the transcript. And my learned friend suggests that that indicates that there's a high threshold for taking action against professional misconduct, But we would respectfully make this observation. Well, first, you have to now take into account cold Floriat. But in any event, the exercise of that jurisdiction and the threshold that was applied to it flowed from the fact that it was the court having to take the action. So rather like contempt proceedings or contempt in the face of the court, you need something quite striking to justify such action. Here, of course, modified by the fact that there are enhanced duties owed by solicitors to the court as officers of the court. But even so, the threshold has necessarily got to be high for the court to decide to exercise its own jurisdiction. That is not a guide to to the proper construction of the statutory scheme promulgated by the SRA. It may have a bearing on whether you go down one route rather than the other, but whether the judge says, I'm referring you to the SRA, or decides to do something about it, him or herself. You say Miller and Friends' argument is misconceived, that you can lift that standard into the statutory scheme. The third sub-point, third and last, I'll call it C, and I can take it shortly. The handbook, that is to say the 2011 handbook, did not prescribe standards by reference to a defined notion of professional misconduct. This is our paragraph 39 in the skeleton.
Yes.
And consequently, that leads to the correct analysis we would respectfully submit by the Divisional Court in Beckwith, that one cannot read across from one scheme to another, from one scheme that does have a defined notion of professional misconduct. This is Beckwith, your tab 34, paragraph 20 at page 1066. I'll return to Beckwith, so may I reserve that point. Point number 5. I should say I go up to 7. But 7 takes in both Lee Day and Beckwith, so it's quite a big point. So 5, the firm's arguments that the judge's approach leads to unjust and disproportionate consequences is rebutted or answered by a number of considerations. This is our skeleton at paragraphs 40 to 43. Largely touched upon a number of them. The first is one such point. Subpoint A, I'll use the abbreviation P7 and 07.5 do not extend to private life. Compare the Beckwith provisions that did, P2 and P6. That's our paragraph 41. And it's the point that we looked at in note 5.1 to the 2011 principles. Point B, proportionality is built into the regulatory structure through all the provisions that ensure that seriousness is considered prior to the bringing of proceedings before the tribunal. This is our paragraph 42. Refer there to section 28, subsection 3, little a of the Legal Services Act, which we've previously looked at. That is to say, the approved regulator's duty to promote regulatory objectives in a proportionate way. I was going to add a discussion of the screening or referral test, but happily I've had the opportunity of already addressing your lordships on it. I don't think we developed the point enormously in the skeleton argument, but I've now had the opportunity to do so.
Yes, I think you have.
And the requirement of seriousness before bringing proceedings is, as you know, because Millennium Friends invited you to look at it, and the learned judge considered it to be important. It's underscored by relevant SRA guidance, that is to say, the SRA's enforcement strategy. I don't think we need to look at it again, because Millennium Friend invited your lordships to look at it yesterday. Tab 58, beginning at page 1455, especially at paragraphs 2.1, I think these are quite long paragraphs, and 2.2, which is pages 1458 to 1465. And they emphasise that the SRA will not bring proceedings unless the matter under concern is serious enough. The money laundering guidance, tab 60, pages 1576 to 1577, which also emphasises that allegations will only be brought when they're serious, and indeed that there is no reporting obligation unless they are serious. And pausing there, we would say that because of the analysis that I've already outlined and invited the court to accept, the notion adopted by the tribunal and advanced before this court by my learned friend, that there is some telling point in the inconsistency, the contended inconsistency of the SRA with its own guidance is misconceived, because the guidance is concerned with the prosecutorial function of the SRA. Point number 6, again, I think I can take this shortly. The grammatical meaning of the promulgated schemes is not displaced, taking account of the considerations I've already outlined, my points 1 to 5, and applying the correct and relevant canons of construction. This is our paragraph 44 in our skeleton argument, and to understand it, the court will wish to have regard to what we also say at paragraph 28 in the skeleton argument about the proper approach to the interpretation of the principles and the code on the strength of case law and the analysis in Benyon. I think we've already had quite a significant trot around Benyon, so I'm going to be rather more modest in our reliance upon Benyon, as we were in our skeleton argument, and the construction principles that may usefully be considered at our paragraph 28, we say the grammatical meaning has the greatest weight and the adverse beneficent consequences, one or the other, or both, are a tool to the construction of the legal meaning. And that is Benyon at paragraphs 11.4 and 11.6, passages at 1683, 1685 and 1686. Putting it shortly, we say that the judge's approach, following the approach adopted by the Divisional Court in Beckwith, has the desirable, or one might say beneficent, consequence of creating certainty. That is to say, that you apply the standard that is articulated. You don't incorporate from the ether some vaguely formulated additional threshold. As the court in Beckwith said in paragraph 18, adding such a requirement would only serve to insert unnecessary uncertainty and complexity. Point number 7. Leaday and Beckwith. We respectfully submit that the judge was right to conclude that the firm's submissions as to both were largely misconceived. Properly construed, Leaday is consistent with Beckwith, but we go on to say if there is a conflict, the Beckwith approach is correct and to be preferred. This is our paragraphs 47 to 51 in the skeleton argument. So I'm going to break this down into consideration of Beckwith and Leaday, but I'm going to begin, this is my subpoint A, with the precursor to Leaday as to the derivation of the seriousness plus idea, Sharp and the Law Society of Scotland, tab 4, pages 95 to 102. And we addressed Sharp in our skeleton argument at paragraphs 51 and 52, in particular 51.3 and 52.2. And we say it is a case that expressly concerned, and I quote, professional misconduct, close quote, and professional misconduct which connoted a high threshold for a breach. And therefore, adopting the approach in Beckwith, which is plainly the right approach, you cannot read it across to this scheme. It in fact, could I invite the Lordships to go to Sharp? It's at page, tab 4, page 95. Sharp concerned a rather odd provision.
Oh, sorry, Zach, just move your microphone over.
Are we back in business? Sharp concerned a rather odd provision which permitted non-compliance with accounts rules to be treated as misconduct, as professional misconduct, in fact. The provision is set out at the foot of the first page. And
May be treated.
indeed, may be treated and also expressly stated professional misconduct. So our first point is that it's not a great start as a basis for construing provisions that don't expressly use the term professional misconduct. And as one sees from the head note, the tribunal in this instance made the error, precisely the point that the Lord Justice Bean has just articulated, of treating the provision as providing for a rebuttable presumption of professional misconduct, when all it did was said that you have the power, in between the lines, in appropriate circumstances, to treat such a breach as professional misconduct. And one sees that in the bottom quarter of the head note at page 95. The tribunal held that the provision provided that a breach of the rules constituted professional misconduct unless the solicitor satisfied the tribunal that he had taken all reasonable steps to prevent it. And the court held that that was the wrong construction of the provision. The important point is this, that the decision doesn't explain the basis upon which the court identified the ordinary threshold for a finding of professional misconduct. But it may be surmised that the rules or common law that was applicable to the regulation of solicitors in Scotland in 1982 at the time supported a proposition in the particular context of this case, that what was required before you triggered the permission in section 23 is the phrase that's now developed a life of its own. You find it at the bottom of page 100. Going on to top of page 101, a departure from these standards, which would be regarded by competent and reputable solicitors as serious and reprehensible, may properly be categorised as professional misconduct. So there were 2 points we would respectfully submit. One is it's referring to the approach in Scotland at the time, but also it's requiring on a case-specific, that's the wrong way of putting it, on a statutory provision-specific basis. It's requiring a high threshold because of the otherwise draconian nature of the permission provided by the particular statutory provision. And we say, we respectfully submit, that relying on Sharp, the firm makes a misplaced analogy that such a case-specific articulation of a principle becomes a universal principle that applies to all other conduct schemes. We go on in our skeleton of paragraph 52. This is potentially quite a case-heavy point, but I think I can summarise it, adopting the helpful guidance of the Lord Justice Bean as to what I can summarise, because we did put it in our skeleton at paragraph 52, together with citation of the key passages. We say that the importation of that principle is wrong as a matter of principle for the reasons that I've set out. But actually, when one looks at the detail of how that kind of approach, the approach of adopting seriousness plus, seriousness incorporating moral opprobrium, has in fact been utilised in other regulatory schemes, it is plain that that reprehensibility element is only built into conduct schemes where the specific context demands it, typically in relation to conduct outside of professional practice. And the court will have seen our citation of the case of Meadow, which drew upon Mr. Justice Collins' approach in Nandy, and then consideration in other cases, Mallon and Holder, about the limited guidance that can be derived from a moral opprobrium element, a definitional chimera. The approach taken in Remedy, which was to identify those kind of elements as being either typically required in relation to conduct outside of professional practice. It was the, as it were, the aggravating element that was required. At any rate, the long and short of it, the gist of it is that you don't always need seriousness plus. Quite often, even in schemes that require professional misconduct, even in schemes that require professional misconduct of a high degree of seriousness, such as the GMC scheme, what you actually require is seriousness, not seriousness plus.
Isn't this a side point? To succeed in his appeal, it would be sufficient, as I see it, for Mr. Kelman to establish that there is a threshold of seriousness. Your case is there's no threshold at all. If there's a threshold of seriousness, then, speaking for myself, I think it may be unnecessary to decide whether Lord Emsley's phrase culpable and serious, culpable and reprehensible, apparently all three, is the appropriate test. I don't myself know what the difference is between culpable and reprehensible, and if reprehensible means sort of wicked, involving moral opprobrium, then plainly this case doesn't qualify on the findings of the tribunal, but seriousness is more central.
Well, the difficulty is, I would respectfully submit, that the SDT purported to apply that test. Wrongly, we would respectfully submit. That's why they kicked out the case. They applied seriousness plus, which tainted their consideration of the question of seriousness altogether. It also has an impact on the other grounds of appeal we would respectfully submit, because my learned friend seeks to rely upon the concession that we don't challenge the primary facts found by the tribunal. But that can't possibly apply to the finding of seriousness plus, because it was an irrelevant consideration dependent upon the application of the wrong test on our submission at the wrong time. But even if, as your lordship, as it were, runs the thought experiment, it was appropriate to consider seriousness, but not seriousness plus, how can one possibly know that the tribunal would have reached the same conclusion? Because it imposed a bar that was far too high. It said, looking at this, well, it may be serious, but it's not reprehensible. Precisely the point that your lordship makes. That's why they kicked it out, by applying the wrong test, a blunt instrument that puts the bar far too high for many regulatory standards.
What are we looking at in the tribunal's decision? Is it just those paragraphs cited at 16 of the judge's judgment? Because you're right, at line 380 it says the test to be applied.
Yes.
But at line 381 and line 482, its decision is the breach was inadvertent, and then line 32, the breach was entirely inadvertent. That's its conclusion, isn't it?
It accepted bag and baggage all of the submissions that were made by my learned friend. Would your lordship give me a moment? Just
Yes.
I think my learned friends are correct in saying that in order to understand the decision, the findings, one needs to look not only at the findings paragraph, but also, to some extent, also the costs determination that followed, pages 247 onwards.
Well, you're entitled to say that the tribunal found at 380 that the test to be applied was whether the breach was serious, reprehensible, and culpable.
Yes, that's precisely
All
the
three
point.
things.
I'm grateful. That was what I was looking for.
But I think I've put to you the following paragraph. I wanted your response to that, because that's the test they applied, but the decision is then expressed in different ways.
Yes, but if one tries to put the pieces together, it's always rather difficult to do so. And for that reason, the learned judge was right, we respectfully submit, but it's a pervasive error. It's difficult for a court on review to disentangle and work out where one would be left if the tribunal was free of the error. But one way of looking at it is that the tribunal took the view that although Mr. Chateau was to blame for a persistent and highly culpable failure in relation to MLR standards, the firm should not be saddled with his conduct, because it's necessary not only to find that it was serious, but also that it was reprehensible in a way that connotes moral opprobrium. And consequently, the factual finding that the conduct was inadvertent by the firm because of all its good systems lets it off the hook, because you can't characterise the firm as being guilty of reprehensible conduct. Now, I don't say the logic follows, because our submission would be that the firm is to be viewed as having allowed Mr. Chateau to wear its shoes. So the decision was wrong on that account. But one can see how the seriousness plus test tainted the finding through precisely the factual finding that Justice Zacaroli has drawn my attention to, the finding of inadvertence. And I should say we don't challenge the finding of inadvertence in the sense that it is intended to mean, that is to say that they had good systems. We say that's not enough, because Mr. Chateau was standing in their shoes as a senior member of the global firm, the vice chair of the global firm, not a regulated solicitor in this jurisdiction, also a partner within the New York firm. And that is enough, because they allowed him to carry out their due diligence and ongoing monitoring. And he did it very badly indeed. Lord, I was about to go on to Lide itself,
Yeah.
if I may. And tab 32, beginning at page 963. It is important, we will respectfully submit, to remind oneself of the context for these observations. So the context begins at page, using the bundle pagination, page 991. So it's allegation 1.8, which is the destruction of documents allegation, giving rise to principles that do have inherent seriousness. I say that do. Principle 5 calls for particular consideration, but Principle 6 certainly does. The context can be found at page, at paragraph 153. Mr. Dutton submitted majority erred in their approach to Principle 5 and thereby erred in principle. He said, amplifying arguments that, as already noted, he had already raised in other contexts, that the majority had wrongly introduced considerations of professional misconduct instead of simply focusing on whether or not there had been a breach of Principle 5. So the SRA's position was that by talking of professional misconduct, the tribunal revealed that it had adopted the wrong approach. And essentially what happened in the passages that follow is that in rejecting that challenge, the court concluded that the language used by the majority, who were impugned with that error, was permissible in its context and in any event made no difference to the finding. And so accordingly, the starting point, we say, is that there is no reason to treat the court's analysis as doing anything more than that. And just reminding oneself, Principle 5 is provide a proper standard of service to your clients. Yes, the allegation was the destruction of the document. Then, could I invite the court to go to page paragraph 150. The majority who accepted AC's evidence expressly found that AC had not been negligent, let alone that the negligence was such as to constitute professional misconduct. And that's why the court then went on at paragraph 155 to say, given the context of this case and given the finding that there was no negligence, we found this debate to be somewhat arid. That's because they found that there was no negligence, let alone professional misconduct. So they were cut off at the pass much earlier. And so we say in the passages that follow in paragraphs 156 to 158, the court was simply analysing the unexceptionable character of the language used by the tribunal. That is to say, there are a variety of respects in which it's appropriate to talk about professional misconduct, to use that phrase. And ultimately concluding, this is skipping ahead, paragraph 161. Foot of it, the reasons given by the majority were both entirely sufficient and entirely cogent, that there was nothing wrong with the language that had been used.
What paragraph?
161. We say, read in its context, that is effectively what it means. And we would submit, for the reasons that we sketched out in our skeleton, I gave the range of paragraphs at the beginning of my outline of my point number 7. we say that the examples given by the court in Lee Day, 156 to 158, amount to no more than an analysis of what degree of seriousness or culpability is inherent in allegations of various kinds. That is why the required seriousness and culpability described by the court in the various examples is proportionate to the extent to which the disciplinary finding stigmatizes the relevant person with blameworthy conduct. So that's why you've got an exception for strict liability. It doesn't stigmatize someone with blameworthy conduct. It just fixes them with strict liability, and therefore you don't need, it would be inapposite to talk about professional misconduct in that context, but it wouldn't in other schemes. So applying that,
can we look at 156 again?
yes,
Just put the last sentence to one
Yes.
side for a moment. Is there anything else in that paragraph with which you would take issue?
well, Principle 5 does not fall for consideration by this court, so it may have to await a determination by another court. But one can see a basis for why the court might be inclined to read into Principle 5 a requirement of some inherent seriousness. Could I invite the court to just glance at the principle itself, page 1345.
Set out on the previous page of Lee Day.
I'm sure it is, yes.
You must provide a proper standard of
Indeed,
service in the order.
Indeed. So there are two ways of reading that. Proper standard may mean anything that falls short even to the most trivial degree of the standard to be expected is enough to reach the standard. Another way of reading it would be proper standard connotes the converse of an improper standard, and the word proper should be read as connoting a degree of seriousness. So one can see a basis for that conclusion with respect to Principle 5. But
I'm interested in the in the lines beginning about 8 or 10 lines into 156. We do not say there is a set standard of seriousness or culpability for the purposes of assessing breaches of the core principles in tribunal proceedings. It's a question of fact and degree in each case, whether the default in question is sufficiently serious and culpable. Thus will depend on the particular core principle in issue. That must be right.
That is entirely right. That's consistent with the way we say these principles should be construed. And it supports the judge's view, adopting the submissions that we made, that I made, supported at the time by a speaking note that we've not placed before the court. The real key to these passages was inherent seriousness, the inherent seriousness implicit in the standard articulated. We say that's entirely consistent with that specific passage that your Lordship has outlined.
But if the final sentence means, it's a bit ambiguous, an evaluation of seriousness remains a concomitant of such an allegation, if they mean any allegation of relating to any principle, then you would disagree, at least so far as core principle 7 is concerned.
Indeed, and we would say that that would be an incorrect reading of the paragraph. It's talking about Principle 5. And one can see how it got there. Whether it's right in importing seriousness into Principle 5 does not fall for determination. But what that passage does not say is all conduct codes require an evaluation of seriousness. In fact, the middle passages that my lord has read out suggest precisely the contrary. And then we say that's consistent with paragraph 157. Likewise, regulatory schemes that call for findings of professional conduct of a kind that connotes reprehensible or deplorable behaviour require such a standard to be met before establishing a breach. That's my my words, not courts. The examples, the citation is significant. Wingate, which concerned Principle 6 and sets out the reason why Principle 6 does involve seriousness, and Sharp, rightly noted as concerning the applicable Scottish legislation and rules, is another example of where professional misconduct required in that particular context, again my words not the courts, a finding of serious and reprehensible by competent and responsible solicitors. So it's just saying there's nothing wrong with talking about professional misconduct. It's used in all kinds of contexts. And then it goes on to deal with the exceptions at 158. 158, we say, is significant. And so is, it's reference to Holden, but and so is the wording specifically referable to the SRA principles, bang in the middle of 158. So moving on from Holden and strict liability, but that cannot be said generally with regard to all alleged breaches of the core principles. So pausing there, implicitly it can or possibly could be said, strict liability, in relation to breaches of some of the core principles. Obviously the court is being guarded in its language, properly not deciding points that did not fall for consideration in the case. And then it goes on to say which, in our view, ordinarily will involve an evaluative judgment and an assessment of seriousness to be made. Well, certainly it does in some, with respect to some standards, such as Principle 6. And then making good my point, I would submit as to what this is all about. At the foot of 158, all that said in the present case, we repeat that this debate under Principle 5 is particularly sterile, given that the evaluation of the majority was that AC had not even been proved to be personally negligent, let alone that the negligence was such that it constituted professional misconduct. So they didn't make a finding that there was professional misconduct, they just used the language. And the use of the language was unexceptionable because it's an acceptable proxy term denoting what can happen in relation to regulated people subject to conduct rules. So that's what we say about Lead A. There are later passages relied upon by my learned friend in relation to Approach 2, so I'll reserve those for Approach 2. So I'm going to go on, if I may, to Beckwith. Tab 34, page 1060. We would submit that the key point for present purposes is that the divisional court in Beckwith, and pausing there, it was the divisional court. The decision is the decision of the court, although I think both the judge and my learned friend have been inclined to talk about it being the judge's comments. The divisional court rejected the existence of a universal seriousness or seriousness plus ingredient into professional conduct schemes. And the notion that it should be imported or read into the SRA scheme. We say that is the effect, the overall effect of the judgment. And we respectfully submit that the learned friend's reliance on the use of the word freestanding reads far too much into it. It means, in the overall context of the case, no more than that. That is to say, that the court deprecates the reading in any way of such an ingredient unless it is inherent in the standard, in the wording of the standard articulated. It's right to say that the focus of the court was on the handbook requirements, 2011 handbook requirements, rather than the wording of the statutes under which the rules were made. And the court goes on to conclude that the handbook, this is paragraphs 14 to 22, does not contain a professional misconduct condition, a point that's agreed between the parties here, before the standards in the principles are met. And in particular, paragraph 22 I'll just read that if I could. It considers the BSB case of Howard. It goes on to say, at the beginning of 22, we do not consider the observations we've just made also holds good for the handbook. The handbook is a reference to the SRA 2011 handbook. Paragraph 4 defines it as a term in the judgment. It goes on to say the handbook makes no use of the term professional misconduct either as a term of art or as a prescribed standard, although it is readily apparent from Rule 10 of the 2011 disciplinary rules that some notion of professional misconduct is used to distinguish between those matters that can be addressed by the SRA and those which need to be referred to the tribunal. It is equally clear that for the purposes of proceedings before the tribunal itself, there is no freestanding requirement that the tribunal must first decide whether the conduct alleged amounts to professional misconduct before going on to consider the application of any of the principles set out in the handbook.
And 22, they are referring to solicitors handbook,
They are.
not,
If
not,
your
not
logic goes back to
bar handbook
yes,
referred to in.
if your logic goes back to paragraph 4,
Yeah.
paragraph 4, penultimate line, the handbook, so defined. It does get confusing because, of course, the BSB a similar structure, the BSB handbook. Now, we say freestanding in its context just means that it is read in when it does not otherwise appear. It's got nothing to do with the stage or the time when it is applied. And to make good that submission, could I invite the court to go to paragraph 14. Records the submissions that were made. About 4 lines down. On the appellant's submission, the notion of professional misconduct provides both a threshold requirement to weed out complaints concerning matters that are insufficiently serious to be the subject of regulatory sanctions. That's a reference to the referral threshold. And also provides a boundary to mark the limits of regulatory incursion into conduct that occurs outside work or otherwise in the course of professional life. So it's a reading in to all standards. It's got nothing to do with attaching it at some later stage in the decision making. Then if one just reads the top of 15, although we agree that such limits to the scope of professional regulation by the SRA do exist, we do not consider it is appropriate to identify where those limits are by reference to a notion of professional misconduct. Well, we say that's precisely the point that Malone and Friends advance, and the suggestion that it's a different point really relies upon a misreading with respect of the decision and the articulation of a distinction without a difference. Then could I invite the court to go to paragraph 24? Having considered Lee Day and interpreted it, we would respectfully submit in the way that I've advanced to the court in substance. The court goes on to say, thus the judgment in Day lends no support for the appellant's first 2 grounds of appeal in this case. Rather, as the judgment makes clear, the requirement on the tribunal is to apply the substantive rules made under Section 31 of the Solicitors Act as they exist from time to time. In the present case, the tribunal made no error by not adding the gloss for which the appellant contends, and not asking as a freestanding question whether what the appellant had done amounted to professional misconduct. So it's not some further stage that floats on top of the process. It's just how you interpret the standard. Precisely the point that is advanced on behalf of the firm and was decisively and correctly, we would submit, rejected by Lee Day. I suppose going one stage further, one might ask, anyway, even if Malone and Friend is right that it's at some later stage and therefore one can distinguish Beckwith and it doesn't stand against him precisely on the point. And what difference does it make at what point you inject this principle derived from Sharp, like some self-replicating Trojan virus of good intentions in the process? You still have to ask the same question. Where does it come from? What is the source for such a proposition? Why is one injecting it into a standard that doesn't include such matters as inherent according to the natural reading of the standard articulator. So we respectfully submit that Beckwith got it right. Beckwith interpreted Leday correctly, but even if one can detect a stress between Leday on the one hand and Beckwith on the other, Beckwith considered head-on precisely the point that is articulated and advanced on behalf of the firm, and it was right to come up with the conclusion that I've sought to summarise before the court. I'm going to go on, if I may, to approach 2 of ground 1. The court has no doubt followed that this is an area that was further developed by way of correspondence between the parties. So the positions that were outlined in the skeleton arguments are set out in the firm skeleton argument at paragraph 19 and also at paragraphs 29 to 32. In our skeleton argument, we dealt with them shortly at paragraphs 45 to 46. There was then an exchange of correspondence, which your lordships may have seen right at the end of the call file, tab 13, between the parties, by which the solicitors for the firm properly invited the SRA to consider specific matters that were being advanced in connection with approach 2 concerning the jurisdiction of the tribunal to do what the firm suggests it is able to do in terms of dismissing allegations that are not serious enough or serious plus enough. Then, as for the references in the judgment, I'm sure you will have this, that the judge rejected approach 2, paragraphs 43 to 45, in which he also considered the specific submissions on the authority of Pabler, and paragraph 80, rejecting the argument. This is tab 5, page 89 and page 100. And so, the firm's argument, as we read it, is in 2 parts. In the skeleton argument and in the letter at tab 13. And your lordships will have seen the SRA replied in some detail, setting out various legal propositions and relying upon cases that have been included in your authorities bundle. The point has significance not only in relation to approach 2, but in particular in relation to the point that I've already sought to address the court upon in relation to approach 1, which is the statutory footing of the separation of functions between the SRA as prosecutor and the tribunal as adjudicator. So, trying to summarise the firm's arguments before I turn to summarise our response to them. The firm's argument, this is paragraph 19 in the skeleton, is that the tribunal has a statutory jurisdiction to hear and determine any complaint and or to regulate its own procedure. And that's fleshed out at paragraph 29 onwards, where reliance is placed upon the Administration of Justice Act, paragraph 16 to 18 of Schedule 2, which the court will find at tab 43, 1234, in particular at 1246, which is a power to regulate its own procedure. And also Rule 6.1 in the Solicitors Disciplinary Procedure Rules, which is at tab 56 at page 1415. And, just to summarise the architecture of those provisions, the Act confers powers to determine and hear complaints in relation to recognised bodies under the rules, and Rule 6 does indeed provide a power to regulate the tribunal's own procedure, subject to other statutes. I think we looked at it yesterday with Learned Friend. The firm then goes on to rely upon Pabler and Grindrod, the SDT decisions, and Lee Day. The letter at tab 31 asks a couple of questions and invites clarification. So it asks, first of all, in relation to section 46(5)(a) of the Solicitors Act 1974, is that a power to dismiss? Does that confer a power to dismiss? It asks, secondly, in relation to section 46, subsection 9, little b of the same Act, is there a power to make a rule to dismiss? And then it asks a point that the court invited me to address, Rule 13 of the SDPR. Are they obliged to certify even if it's not serious? To which I answered, yes.
Yes, we covered that earlier.
Indeed. So, I'm going to begin by looking at Pabler and Grindrod. I don't know the extent to which I need to go into much detail about them, because I think what I'm going to say may be uncontroversial between the parties. That is to say that both cases by the SDT, both cases are decisions of the SDT in which they concluded they had a power to dismiss a charge if they thought I think perhaps I should look at it before I describe it in a way that may not be entirely apposite. So it's within your bundle. Tab 21. Page 420.
Yes.
George, give me a moment. I've got to switch to electronic for this purpose. Then 420, may I invite the court to go to page 425.
Yes. Paragraphs 37 and 38, that's clear
Indeed.
enough. Whether they're right or not is a matter of argument.
Well, my lord has the point. The secondary point is there is absolutely no legal basis for that proposition that is set out. The proposition that charges can be dismissed on the basis that they were not sufficiently grave to merit a finding, even where the breach is established.
Right. And what about Grindrod?
Well, Grindrod effectively does the same thing, and it specifically relies upon Pabler in doing so. It's at tab 25, page 515, and I think the key passages as I identify them are at page, are paragraphs 142. I beg your pardon, yes. At 142 to 143, the tribunal held that the interests of justice required allegations founded on technical breaches be dismissed. And the key passages are at 142.42 and .43. Technical breaches relying on Pabler were dismissed, and at 143.6, page 574. So the long and short of it is, Pabler just assumes the power on the submission of leading counsel. It was in fact Treverton Jones, Queen's Counsel, so a better source would be hard to find. But they just assumed the power without examination of its foundation, and Grindrod does the same thing. What we said in our submissions, our written and oral submissions to the judge, was that Pabler was devoid of legal significance. And effectively, the judge held that it was. All that it establishes is that the SDT has adopted that practice. It does not examine whether, in fact, it was empowered to do so.
Seems rather odd that if these two decisions were made now 12 to 15 years ago, they were never challenged by judicial review, as humanly they could have been, and no attempt was made to elucidate the point you've argued in the rules.
Yes.
Which again, it could have been.
Yes. It has been cited in subsequent editions of the Solicitor's Handbook by Treverton Jones et al. It is fair to say. I don't know why no challenge was made at the time. I don't have instructions. I've not sought instructions. But from a commonsensical perspective, the court will know from its own experience that sometimes decisions are made about the cases of sufficient importance to use valuable resources funded by the profession to make challenges. And sometimes that takes into account, quite properly, the outcome and the overall assessment of whether there is a profound injustice that would be left unaddressed if no appeal is brought. But obviously, like many cases, it has taken on a life of its own subsequently. which may perhaps not have been anticipated at the time or within the period of 3 months following its promulgation.
This is Pablo.
Yes.
Fact. And there's no SDT decision saying counsel for the SRA submits and we agree that Pablo was wrongly decided.
I'm unaware of one.
Mr. Coleman, you looked as though you were about to leap to your feet. Is it?
Yeah, I mean, sorry, I hope
Yeah.
it's thought appropriate, but I
Yeah.
just wanted to correct a possible misunderstanding, otherwise I might forget the point. And that is, your lordship said, I think, or asked whether Pablo had been subject to the judicial review. In fact, there is an absolute right of appeal under section 49 of the Solicitors Act against decisions. So permission is not required. So it could have, in fact, it
Oh,
could
I
have
see.
been appealed.
Yeah.
It's an even lower
Yeah.
test.
Yes. Right, is that a convenient moment to break off, Mr. Osin?
How
How are you doing?
Just one footnote. It's been helpfully pointed out to me that the judgment itself records that there was an appeal, but it was withdrawn by consent in the case of Pablo.
Yes.
It's a sliding doors moment, perhaps.
All rise in favor